Everybody, welcome to week 221. Hey, next week, welcome back, Cotter 222. Remember that? He was in room 222. So anyway, yeah, I'm dating myself. Anyway, you guys know what to do. Hit us up on the Q&A. You can harass us on the chat, and Papa Joe will be sure to do that if he's on. I did talk to him recently, and he's doing well. So anyway, Adam, I'm going to kick it over to you. So we are going to talk about the dumbest legal moves that, or, mistakes, I should say. Maybe it's lack of movement, but that business owners make. And we may have to do another repeat on the dumbest tax moves or blunders that business owners make, because we didn't get through all of them last time. So, but we're going to go legal. But before we do that, Adam, you got any rants?
Yeah, so we've been trying to preach no, hey, regardless of who wins, it'll be fine. Let's all just step back and calm down a little bit. So I got asked a few questions lately on check-in calls around, hey, what happens if there's a Harris presidency, and hana blah blah blah. So gave the usual spiel we've done on these webinars about what the likely tax rate increase would be. And one of the clients said, hey, I saw kind of the economic analysis, and it said, hey, that could be a slight reduction in jobs and GDP. What do y'all think about that? That seems kind of bad in general. And I guess what I wanted to say about that is that, yes, people, unemployment rising slightly, and this is like, a quarter point or something like that. Like it wasn't, and then GDP, less GDP growth by like 0.5%, like that all, would seem bad. And at the same time, the balancing act of that is like relative to more debt. So it's all, I'm not advocating one way or the other. I'm just saying, like, there is no sunshine, rainbow, unicorns. Yeah, I get to eat it. So let me actually use a different analogy. Most everybody knows that I don't drink anymore. But when I was drinking, Gary, I did several Google searches on drink
I know where
beer
you're
and
going.
still have a six pack. And the page 1, 2, 3, and 4 results were, you really should probably only have, one or two beers a couple times a week, which was reasonable, insane advice that I didn't really appreciate or want to follow in particular. But on like page 5 or 6, I actually got the honest answer. Yes, it is possible if I'm willing to put in, 2.5 hours a day of cardio. I'm like, well, at least now I know. So my point in saying all that is we had a little joke before we got on about the Island of Misfit Toys. So Jack Starbucks gift card on where that came from. But you know, related, it's like, what was the name of the island in Pinocchio? Where the wayward boys, they get eat candy and everything, and then they turn into donkeys.
Oh, yeah.
Yeah, I don't remember, but
Yeah,
yes.
whatever. Pleasure Island, I think, was the actual name
Was
of the
it?
place. Yeah, I think it was called Pleasure Island. But that's another gift card, by the way. Jack's gonna run out of gift card. I'm giving Jack's gift card. In other words, like, I'm sort of like Congress. I'm just gonna give shit away with no consequence to me.
Right.
Only consequence to Jack. Meaning, like, again, there's no right answer. And I think if you just kind of look back through history, you know, stock market's fine. It's gone up regardless of administration over time. Companies have made money regardless of administration over time. Nobody I've never met a business owner who said, hey, Gary, I'd love to actually make more money, but because of taxes, I'm not gonna, you know? So I just, regardless of what happens, it's all going to be fine. So let's not panic, let's not panic about it. And at some point, somebody's going to have to pay the piper around here, regardless of administration. But the punchline is, even like what I would suspect would be the likely scenario again, and I know I'm just repeating it again, is that, tax rates will probably go up on our clients, which are, primarily flow through business owners. So owners of S corporations and partnerships by anywhere between, 5% and 10%, but they'll probably phase that in on income. Right now, they're saying income at 400. I can see them raising that up to $1 million or $2 million to get really targeted on closing down on, like, well, even the rich people would say that's rich, like, in other words, they'll close it down on, like, nobody's going to boo-hoo about them, type of people, implement some sort of corporate, minimum tax so that large corporations have to at least pay something, and then at the same time, to offset sort of any economic consequence, what I'd see happening is like, hey, let's get a sugar high from bringing back bonus depreciation back at 100%. Like that. In other words, like, that's a classic move. Got to raise some taxes, but here's your candy bar. Hey, I made you a big plate of broccoli, but there's a Snickers bar right there for you, too. So, like, and I think that's probably regardless of which administration takes over. I think if Trump, if it's Trump and it's Republicans, then the likely scenario is, extension of the Tax Cuts and Jobs Act, so they could say they do it, probably would also do something around depreciation expense. And at the same time, highly likely take something else away to pay for it, just like in the last tax code, they took away the ability to deduct state tax payments. So, so they can get it as close as possible to revenue neutral, because it's just a reminder that I think it's the Byrd Amendment, if I'm not mistaken, but there actually is a rule in Congress, which is the whole reason the Tax Cuts and Jobs Act expires, is that at some point, you can't do a tax cut without that's permanent based on revenue growth exclusively. Otherwise, they are temporary. Now you keep on extending it and extending it and extending it, if you want to, but at some point it's got to be, at some point it has to pay for itself. Like the CBO, the Congressional Budget Office, has to show that it pays for itself. So, which is why these are set to expire, is because, back when they passed it, it did not show that it was going to pay for itself, but sort of the bet was, hey, there'll be enough economic growth that it'll offset it, and then assuming that's the case, then we'll all be happy and decide that we want to make it permanent or pass it. That's not what the reality is showing, just based on the deficit growth, which is, again, both administrations contributed to that based on the economic stimulus associated with the COVID-19. So in other words, wow, I'm sounding kind of doomy and gloomy. I should shut up now. Turn it over to Jack. Not diet and exercise, Gary. That's what we need. Diet and exercise, alcohol and moderation.
Diet and exercise.
Yeah, diet and exercise, alcohol and moderation.
Yeah.
Not sucking off a sugar tit.
Well, I can tell you this. I loved working with Adam Boatsman before he quit drinking, but I love working with him even more that he has quit drinking. And I also quit drinking. I was a 1 beer once a month guy. And 2 years ago, I was like, as much as I like the taste of that beer once a month, it wasn't helping. My numbers weren't the way that they needed to be on my blood work, so I got it out. So whatever. But I'm with you. Healthy lifestyles. But so here's one thing before I toss it over to Jack, because this was timely. So remember, we started this thing before it was even called CARES Act and before EIDL, before PPP, et cetera. But I was with a commercial banker on Monday, Thomas McTeer with UCB, and they and Pinnacle in particular did a lot of help with a lot of our clients that were stuck in the machine of the big banks that weren't coming through for them on PPP. And ironically, while I was driving to lunch with Thomas, I heard an ERC ad. And I'd heard like two within the last few days of that. And so it was just on Monday when I had lunch with Thomas. And I'm like, what in the world? Why are they pumping up ERC ads again? Like that's costing money, and it wasn't just remnant supply. So I thought something's up, and I said, hey, have you heard anything? And he said, yeah. He said, supposedly they're doing a little bit of something, but he said, I don't know what's going on. So what did I do? I called Stephen Swanick last night with ERC Today, which they are the provider that we've used for a lot of our clients. And I said, hey, Stephen, what's going on? Are they releasing the valves again, or what's going on? And he said, actually, there was this big lawsuit that happened in Arizona, and it was called Stenson Tamadon versus the United States IRS. And an injunction was filed, and he said that was actually a good thing, because if they actually won, then the IRS would have just stonewalled and just appealed. But he said this judge fired some shots across the bow, and some of the language in that document were really interesting, because basically what was happening is, and Stephen said, of the 1,900 that have been approved, and these guys are very conservative. They were like strike zone only. Are these going through? And right, the IRS shut it down because there was all kinds of fraud, blah, blah, blah. But they have been, they just shut it down. They thought, well, we'll just slow walk this thing, evidently. This is something that's interesting from the judge. He says, the court can hardly think of a starker example of having one's legal rights or obligations altered than requiring a lawsuit to proceed in the same manner as one did prior to an agency's, IRS, unilateral action. And similarly, and he cites another place in the suit, also requires the commissioner to proceed to process all eligible refunds. In the case of an overpayment, the secretary shall refund any balance to such person. Thus, the moratorium cannot last forever, or else it would be a de facto cancellation of the program. So, his point is, hey, it's affecting people that should have had this program, and a governmental agency can't just unilaterally shut it down, slow walk it, and hope it goes away. And the IRS's defense it evidently was, well, this company that brought the suit, was kind of like ERC Today. You weren't harmed. These other individuals have to file the suit. Well, guess what? You file a suit, it costs money, to do that. And so the IRS knew that. So I just thought that was very interesting. And so what's happened, of the 1,900 legitimate claims that have been waiting in the queue for a long time now with ERC Today, they've released 30. 30. That's it. And none of those, I think, were our clients, Adam, just so you know.
Yeah.
So anyway, I just thought it was very interesting time-wise, because like we talked about ERC, hey, they shut the valve off. And then all of a sudden I'm hearing ads again. So if you're tempted by an ad, beware, be very careful. Go with somebody that's extremely conservative and make sure that you're in the strike zone, because these guys are hunting. The IRS is hunting for anybody that claims stuff. And what's interesting, Stephen also said before I toss it to Jack, was they indiscriminately denied some that were like in the center of the strike zone. So he said they're having to appeal. And he said it just seemed like there was no rhyme or reason for anybody that was being denied versus those that were being let through. It wasn't based on size. It wasn't based on industry. It was just kind of very haphazard. So there's going to be more to come on that, evidently. But enough of that. Jack, let's hear about some of the dumbest legal moves or lack thereof that business owners make.
All right. So a couple of administrative things. First, regarding health and everything else, I went to the Imagine Dragons concert last night, and so I did participate in alcoholic beverages, but I'm glad to report that I am much more conservative in my 50s than I have been in prior decades. And so, yeah, I was fully able to drive home, and all was good, as it should be, right? Okay.
That's good.
Secondly, a shout out to your colleague, Carrie, who we have a mutual client, and because of a typo, we had requested some unaudited information, unaudited financials to put in a franchise disclosure document. And there was a typo, and Carrie provided what we asked for. And then we said, whoops, we actually need a different period. And she said, no problem whatsoever. And, people are human and make mistakes. So just a shout out to, what you guys would expect, but just a shout out and a thank you to BGW for, fixing that, but, being generous with their time and not saying, and we're going to charge you for the fix as well. So, thank you for that. The, continuing
we
on.
didn't bill you guys like an attorney would bill? I'm just saying.
I was reluctant to say that last part with having, Adam on the line and you on the line as well. So I did offer to pay otherwise, like, bottle of wine, or, I should have offered a Starbucks gift card because I have
There you go.
right? So anyway, yeah, I'm picking up kind of where we left off from last time, but I do want to mention, because we're not going to necessarily talk about it unless somebody wants to, but on this whole FTC initiative to ban non-competes and to invalidate prior non-competes, we had mentioned that the federal court in Texas had invalidated or put a stay on it, and it was a nationwide stay, not just linked to the individuals or the groups that had filed for the stay for the injunction. And then kind of, having another week of discussion and everything else, including within the International Franchise Association, IFA, I'm hearing that it's basically dead in the water now, that even though the FTC has said they are thinking about appealing, that it would be an uphill battle, and it's just not going to go anywhere. So hopefully, depending on which side of things you're on, that's good news, or maybe it's bad news if you were hoping that your non-compete that you signed a few years ago would become invalid or voided. So I want to start out with kind of related topic on independent contractors and employees, and that a lot of times there's misclassifications on that. And so what happens when that happens? The end of the story is that if an employer misclassifies an independent contractor or an employee as an independent contractor, and has, for whatever period of time, paid the independent contractor 100% of his or her wages, meaning has not removed payroll tax, as a trustee of the federal government, because that's what employers are when they take this money. And that's how many employers get in trouble. If you read the paper or read the back end of the Charlotte Business Journal, they don't put as many of them in there. But when you see that the payroll tax liens that are placed on employers, a lot of times it is because they've collected money from their employees, but have not dutifully and timely submitted those funds to the federal government, and they no longer have those funds in their bank account. Amazing, right?
Wait.
Yes.
Are you saying that if cash flow is tight and you've collected the money, but you didn't just kind of use it for yourself just to get by, that's not okay?
Yeah, unfortunately, you can't make yourself a lender and a borrower of someone else's money, meaning the federal government's money, because it really is their money. You're I use the term loosely, but you're a trustee, kind of like an escrow agent on behalf of the government, because you have control of those funds, right? And so yes, well, what will happen is that you will have paid 100%, not taking out the payroll tax, and then that person is deemed an employee through whatever means, whether it is going through Department of Labor, it's a Wage and Hour Act violation, whatever it may be. And let's say, just assume that that person is deemed to be an employee. Then the next thing is the federal government saying, then where's our money? Well, I gave it to the independent contractor because he's supposed to pay his own. He's self-employed. Yeah, okay, we see that, but we still want you to pay us. And then you go after that employee that you paid because, they probably were thinking that they were really employees. And so they were saving that money up and not spending it. Um, or we know they spent it because they didn't pay the government themselves. And that's why all this has started up, is because the federal government's waiting for some money, and they quite candidly don't really care where they get it from. But they ultimately will hold the employer responsible if there's a misclassification. So then you get into, all right, well, what does that mean as far as being misclassified? And it gets a little more complicated in the sense that you have the IRS's definition, and then you have kind of the North Carolina Department of Labor's definition as to what is an independent contractor versus an employee. And I'll just give you some sampling as to what that means. So the IRS implements what they call kind of common law rules. And what that means is there's three categories, kind of three factors that provide evidence of the degree of control and independence. There's behavioral, which is, does the company control or have the right to control what the worker does and how the worker does his or her job? There's financial. Are the business aspects of the worker's job controlled by the payor? If these include things like how the worker is paid, whether expenses are reimbursed, who provides tools, supplies, etc. And then there's the relationship test, which is, are there written contracts or employee type benefits like a pension plan, insurance, vacation pay? Will the relationship continue, and is the work performed a key aspect of the business? Or is it something that can be, you said conversely, is it something that can be encapsulated, performed, done, and then, maybe there's another opportunity to do another job for this company that has employed you as an independent contractor. But if it's more recurring, and it says businesses must weigh all these factors when determining whether a worker is an employee or independent contractor. So, and then there are issues about remote workers, and are those, because now it is one thing removed. They're not showing up to your office and getting their instructions. They are getting them remotely. So does that push it more into the category of independent contractor? Those kind of things. So then you turn to the North Carolina Department of Labor, and then they have their factors, which they say were kind of put out by the U.S. Supreme Court, but have been adopted by the state government. And similar themes, but if you're in state court versus federal court, it may make a difference. It does make a difference. Extent to which the services are an integral part of the principal's business, permanency of the relationship, alleged contractors' investment in facilities and equipment. That's another way of saying, okay, who's providing tools and things like that they're using, nature and degree of control, opportunities for profit and loss of the business versus the job that they're doing and they're just getting paid. So is there a factor as to the the cost of doing business that is part of their compensation? Initiative, judgment, foresight in open market competition with others required for the success of the claimed independent contractor. So again, are they making business decisions for themselves? Or are they making business decisions that have an impact on the overall business that they're working for as an independent contractor? And then degree of independent business organization and operation. So, not every independent contractor is an LLC or a corporation. A lot of times it is a sole proprietor. It could be someone doing a DBA. They may have a business address and phone number, but that doesn't mean that they are a separate legal entity. Conversely, just because they are a separate legal entity does not mean necessarily that they are not an independent contractor. So you don't get into, that isn't you can't say, well, it's an LLC. We must have an independent contractor relationship. I will also say that, and we've had employers and employees come to us and say, well, it says it right here in this contract, in this writing that was signed by both parties. And because both parties put the words independent contractor in writing, it must be true. So you can tell the sarcasm in my voice and how I said that, obviously that's just because you put it in writing, to arm's length people negotiating a contract and decide that, oh, well, this is going to be an independent contractor relationship does not make it so. So, and then you get into nomenclature similarly. So, independent contractors, sometimes called freelancers, consultants, self-employed professionals, side giggers, and but it all comes back to, and this is another article it comes down to control over the worker, type of work. And then the reason why I'm bringing this up is it talks about, do you need specialized expertise or just another helping hand? So, that you have to go out and hire someone for a particular expertise might indicate it's more of an independent contractor because it is for a specific issue that is being addressed with a specific job, versus having a specialist that is an independent contractor but is working on many jobs. You can see how that might be more difficult to ascertain because it is a specialist, and just because they're doing multiple jobs doesn't necessarily make them an employee. So it comes down to what many things do is it depends on the circumstances of the situation that you're in and the relationship between the two. But because it's on the list is because this happens often. And I'm sure that you guys see it often as well, because you guys have to deal with the accounting aspects of it when the federal government doesn't get paid, and then maybe even participate in the asking for forgiveness and maybe even a payment plan to the feds on behalf of a client, and helping the client assess what they're capable of repaying. So putting together the repayment plan so it doesn't break the bank. So, there isn't a huge impact on cash flow and being able to pay other bills. So I don't know if you guys want to have any comments on that as to your involvement in this lovely situation.
They're not usually very understanding. Pleading ignorance of the rules, never, to your point about the sarcasm in your voice, pleading ignorance of the rules usually doesn't get you very far. And even I was relying on somebody else's advice doesn't get you very far.
Yeah, and let's say, I'm sorry, go ahead, Gary.
Yeah, I was just gonna say, are we seeing more frequent, prosecution of that lately versus other times? I'm just curious about, because we see it, but I'm just curious, Adam, you've been in the saddle a lot longer in this world than I have. Are you seeing an uptick in it, or is it kind of steady state and it just happens because a lot of people make these mistakes?
It's kind of steady state. I mean, the only matter that I can think of recently where, this has come up is, less of a scenario around the classification. Rather, it was a construction company, and, I know we'll be shocked by all this, but perchance, some of the people paid, just saying for a friend, might not have been in this country legally.
Uh-huh.
And, you don't like when that, is that great that happens? No. At the same time, if you suddenly said, we're deporting all people who are here illegally, you might as well just shut down construction and the restaurant, hospitality, and farming. So there's a procedure. You're here illegally, but pay your taxes. Meaning, like, resident, you can be here illegally, but be legal on paying your taxes without the threat of deportation. And, people actually do that. And it's actually supposed to be up to the employer to actually go through that process, with somebody to say, look, you're here illegally. I'm an employee anyway, so let's get you a taxpayer identification number to be able to pay taxes on your behalf. So this company did not do that. And the IRS disallowed the entirety of their labor expense, which was mostly independent contractors. So if you think about it, it's like construction company, doing 10 million bucks, 3 million disallowed. And it's like I'm basically hanging my argument on, yeah, I know, but if you look up the SIC code for this industry, you can clearly see that that's not a gross profit. That, like, in other words, like, if the IRS is trying to die on the hill of, like, well, then we just don't think the expenses really existed. It's like, come on, like, that you can't actually do this business, without the labor, right? Like, they were wrong. So then the IRS's next position was, well, then who's going to pay the taxes? Like, I ain't getting, so at a minute, like, if I'm going to allow you the deduction, y'all going to be paying their taxes. So it's like, it's not, it's better, than it was before, but it's still not where the client wanted to be. So that's where I've seen it. And rightly so, rightly so, because a lot of people do play this little dance, willingly or unwillingly. And it's kind of, it's part of the, it's part of the, kind of dance around the theory of, like, I want to pay lower taxes. This is all a bunch of BS. Everybody needs to pay their fair share. Okay, there are some people who just flat out freaking cheat. and these are them. So can we just start with the cheaters? And then once we roll off the cheaters, let's move into, shenanigans. And once we've gone through shenanigans, then let's focus on aggressive positions. is my order of preference.
Yeah. So to piggyback into that, just one observation. And so here's a Starbucks gift card for anybody. Without Googling it, what was the brand that said in their advertisements, you can pay me now or you can pay me later? Just think about it. If you know, and I know who it is because I was in advertising, so I remember that one. Jack will get a Starbucks gift card to you. But here's the point. we see it in sales tax work as well, where, and the point is, if you're going to pay me now, like, it's way better to check. Yes, you're right, Fram. Good job. Well, it was Fram oil filters. It's far better to check with a professional on the front end and pay it versus don't and hope that nobody comes knocking. And then when the IRS does or something happens and they come knocking, and oh, by the way, that money that you would have spent back then, you've spent on other stuff, they still want their money. And usually with interest, or they want, they want their pound of flesh. It's far better. An ounce of prevention is worth a pound of cure. So, heard my grandmother say that a lot. So anyway, good job, Will. You got the Fram oil filters.
And I would agree that it's been kind of consistent, and it's been manipulated in the following way. So it is, in the past, has been linked to construction companies, landscape companies. And so then you have the IRS come in and they are like, okay, let's look at your employee list, etc. Oh, show us the I-9s, right? That's the form for verification. And then they start getting into not beyond the scope of what they were there for, which is, and then now what was happening in years past is, oh, well, let's call INS, and bring them into the mix of things. And so because of how it became, the optics of it became prejudicial and racial, maybe, I don't think well, there are people that were saying it was intentionally done because of that, but I think, at least it was just the outcome of it, because of, well, you have people that are illegal in this country, but they're working and they're making wages. And so then it got to, well, let's kind of look the other way a little bit and let's get paid. And, so a lot of programs came up that way, which is, if you self-report on this issue, like a money issue, then we're not going to ask you about anything else in your life, like, are you here illegally or not? So it did evolve and then devolve into what it was supposed to be, which is, okay, are you paying? We just want to get paid our taxes. And so we haven't been paid by this person's work. Who is going to pay it, essentially? So going into the next topic, I'm going to shift into intellectual property and talk about how, in fact, I had this conversation probably about an hour and a half ago with a client who was asking me about whether or not they should protect their trademark. And when I saw the trademark and saw that they've been using it and what they're using it for, I said, absolutely, yes, you should have done this, not to shame him, but or to talk down to him. I was like, you should have done this a long time ago. And I'm sorry that whoever who was counseling you at that time didn't tell you that, because we need to do this like today. So it will be done this week, either today, tomorrow, or the beginning of next week, because it needs to be done. I told him that 15, 20 years ago, and you guys know this, when you guys are assisting with valuations, is that banks really didn't care about or allow you to borrow upon the value of your intangible intellectual property rights. Kind of rewind the tape a little bit to 25 years ago, where the internet wasn't as prevalent. We didn't have as easy access on our mobile devices and everything else. And so, what your logo is, really, did it have a whole lot of value? Fast forward to today, absolutely. It is and we've talked about this in other sessions, about the attention span of individuals these days, and that you have to do something to grab their attention, and you only have nanoseconds, and I'm exaggerating, but a very short period of time to do that. And so how do you do that? It has to be through imagery. through logos, through short phrases. And so once you spend the money to increase the value of your intellectual property and increase the goodwill, a buyer, that's important to a buyer. It's also important to a bank to understand what is the value of this intellectual property. And as we've said before, conversely, if you haven't protected your intellectual property, then you got some explaining to do to a potential buyer as to why not. There might be a purchase price adjustment or maybe some escrow money associated with, let's see how this turns out once there's a big press release that we bought this company, and then someone comes out of the woodwork and says, well, wait a minute, we've been using that mark for 25 years. You're infringing, and Mr. Buyer, and you need to stop using it or pay us a ton of money for it. And so things like that come up. And so what I see is a lot of people just not really understanding the value of what they have until it's kind of too late, which is you're selling a company and you're like, well, wait a minute. What do you mean I can't get value for that? I spent this ton of money and everybody knows us and we spent money on the Super Bowl ad, whatever it may be. And you're just not getting the value out of that because you haven't protected the intellectual property correctly, specifically with trademarks. I mean, there's copyright and patent protection and trade dress protection, but I'm really speaking towards primarily trademark rights. There is a lot of assuming going on, understandable, that if you have it in your name, in your business name, that you get intellectual property protection for that because your name is your logo, your name is your trademark. And that is a huge fallacy in that you might have maybe some common law rights, but you cannot use it, a registration with the Secretary of State of your respective state as a weapon to first send out a cease and desist letter and say, stop it because I have this registration, it's my company name, by itself. I'm not saying you can't use that as a weapon against someone, or is it preventative from someone trying to seek a trademark registration? What I'm saying is that it is not as strong to be able to go after someone for trademark infringement because you really don't have those protections. The reality is that in comparison to the cost of having to litigate this or protect your brand and not having a federal trademark registration, the cost of going through the process of registering a trademark is significantly less than the cost of not doing it if something comes up. If you are asked, okay, well, we don't think your company is as valuable. Yeah, that, word out on the street is, yeah, they're the best, but, okay, how are we going to protect that when someone tries to use the name moving forward? We can't point to the fact that we have purchased and via assignment now own the registration rights for the mark that was filed in 1996. And so those are the things, and that's why I bring this up as kind of my number 2 for today, which is just understanding the value and not protecting it. The process is you go through and you do the search to see what's out there, and therefore you can to file a better application. So the words that you use to describe the goods and services are better, and they are distinguishable from someone else's goods and services description that might have a sort of a similar mark. Because if you don't do that, then you're going to get the reply back, which is called an office action from the U.S. Patent and Trademark Office that says you cannot have your monopoly, because that's what a trademark registration is. You cannot have your monopoly, your federally granted monopoly over these words, these symbols, because someone else is using it. They have been using it longer than you have or registered it already. And the test is likelihood of confusion. There's a likelihood of confusion that, and here's another misunderstanding. It's not a likelihood of confusion of goods and services. It is technically the confusion between the source of the services. So if someone were to use a similar logo or mark to Shoemaker or BGW, and there is a trademark infringement, what you're saying is not that, okay, business was diverted. I mean, that's really what is happening. Business was diverted because someone is trying to use a mark that's similar to ours and confuse people. What you're saying is people are confused as to the source of the services. So when they are looking for this awesome CPA firm in Charlotte on Camden Street, Camden Avenue, that they look up and they find BGW or BGWW, okay? And they've done their SEO so that they show up first, and then that person hits BGWW that happens to be in Valentine, and then they're like, okay, and then they maybe even realize that they're at the wrong place, but they're like, well, I'm here already, had a discussion with them, and I'm just going to use them for CPA services, and they're probably just as good as BGW, you know. All those things potentially go through their minds, which also would be a fallacy if that happened to pop into their minds, right? But the point is that you're confusing the source of the services. But what you really want to do is make sure that business is not diverted, first of all. So you may use it as a weapon offensively, but then kind of defensively. So let's say that Adam and
Hey,
Gary
Jack,
come to me, and yeah, Adam and Gary
we
come to me.
actually
I'm sorry, go ahead.
we actually have had that happen to us.
Oh, really? See, okay.
Yes. And it wasn't based on our logo, it was based on anything but typical being a registered trademark. So Ben and I launched the podcast in 2019, and then early 2020 was our first guest. And then we decided, you know what, we need to register that and we registered it for BGW because that's a positioning statement for us. And so we did get that registration, that trademark in 2020. In 2021, a competitor was using anything but typical, and they were positioning themselves as that for recruiting. And we had to send them a cease and desist, and as soon as they saw that we had that registration, boom, they had to back off. And it was an ounce of prevention versus a pound of cure, because it's effective. It's who we are. And I can see why other people would want to say, oh, well, we're not typical either. But we actually own that registration and that trademark. So
Yes.
it actually happened to us here in Charlotte, North Carolina, within a year of registering that trademark.
And I hear that story a lot. And what should have happened, and kind of part two of the reason why you would file for a federal trademark registration, is because what they should have done is they should have done a search for that, and they would have found it in the federal database. And so their attorney should have gone back to them and say, hey, sorry, there's some people that beat you to it in 2019. We can file, but you're wasting your money, because the USPTO is going to come back and say, hey, there's this company in Charlotte that we can't grant you your registration because it will create a likelihood of confusion as between them and you. And so that would be end of the story. And because it's exactly the same. I mean, that to me is dead in the water. And I've had those conversations with clients. I'm like, hey, I'm sorry, this is dead in the water. And hopefully it's a client that has not spent a lot of money on marketing that. But sometimes it's 18 months, 2 years into it, and they've poured a lot of money and effort into branding that. And it's a fight. But if you have the superior rights, then they just need to come to that conclusion. Because here's what's interesting about federal trademark law is that there is a presumption of innocent infringement, that, yeah, we didn't know. Yeah, we probably should have looked, but we didn't know. Once you put them on notice and they continue to use it, now it's purposeful infringement. And now there's the interesting about the statute is there are statutory penalties. So in most cases in litigation, when you have a claim, you have to prove damages unless you have a statute that says you don't have to. This is one of those areas where it says you don't have to prove that you lost $100,000 because there was $100,000 of business diverted away from you. Or let's say it's 200,000, but 100,000 net. That you don't have to prove the revenue, the net profit, and then say now they owe, because that's just, it's
That'd be
unreasonable.
tough. How
Yeah,
would you prove it?
yeah. I mean, you'd have to go through it because that breaks down at the moment that I'm being deposed and someone says, so Mr. Santinello, we'd like to know what caused you to choose a company B over company A. Well, it was by accident at first. So are you saying that if company B had not done this and infringed, then you would have gone to company A? Well, not necessarily. I mean, I'm always going to be shopping around the market, and they could have been called something else and I might have still found them. As soon as that happens, then there is no direct line of causality that caused me to go with company B. It was because of their advertising, because of their mark. So I'm getting way down in the weeds, but understand there's a cause and effect into this. And what you're trying to do is make sure that we don't really care about cause and effect. They did it. We told them to stop. They didn't. So now it's not innocent, it's purposeful. And here's the statute, and it just becomes a multiplication problem. How many times did you do it? How often? For how long? And then here's the number. And then that's what you allege in a complaint when you're filing for infringement. So I get a little bit fired up about this because it's low hanging fruit to do the filings and then reap the benefits of it from the moment that you file. Because when you file, even though it takes about a year, 8-12 months to actually get that piece of paper with the golden star on it that says you are registered in the Federal Registry, that again, that attorney that's searching, that BGWW attorney that's searching, let's say you didn't have your registration for anything but typical, but it was in process, you had filed it, that still is dissuasive to me to continue with an anything but typical, maybe misspelled or anythings but typical, or anything typically, or any variation like that. It's going to be dissuasive to me and give me a prompt to change it to something else.
Yeah, it makes sense. Makes sense.
All right.
So you got time for another one?
Yeah, let me throw out two quick ones, and it's dealing with defaults. First, with lease defaults, I think that and understand that as a tenant, and if the landlord's not doing what they were supposed to do, what they promised to do, whatever it may be, the frustration is, why should I continue paying my rent if they are not doing what they're supposed to do? Why do you ask me to do what I'm supposed to do under a contract that they have breached? The reason being is that whatever the breach exists. You don't want to give them a counterclaim and give them the ability to, first of all, call you in breach, and then when you don't pay, kick you out. Because most leases will say, regardless of what's going on between us, if we landlord have screwed up royally, you still cannot offset your lease payments, your rent payments to us until essentially we resolve all of it, right? And so that happens often. And I just cringe when I hear that from a client. I say, okay, you're still paying rent, right? And I'm like, yeah, no, we're not. We stopped doing that because we just, basically we felt like all we were doing was giving them money to put in a legal fund to fight us. Like, okay, well, maybe, but that's not your call to make. And so that happens. Relatedly, in loan transactions, lending transactions, maybe unbeknownst, or maybe you don't remember that in the middle of those loan documents, or maybe some covenants that says you shall do these things, you shall not do these other things. Some of the shalls are maintaining ratios of operating capital, of whatever it may be, to debt. There's all different types of ratios, and we kind of as things are going along, maybe meeting those ratios, and maybe as time goes on, not meeting those ratios, but no one's saying anything about it. So be mindful of what you agree to in a loan document, because there's some longevity in them. And so when your financial conditions change, for the worse, not necessarily the better, because if they're for the better, you're going to meet those ratios. But well, let me take tangent on that is, if they go to the better, there may be another tier of whatever it may be, responsibility or covenant or whatever it may be, to maintain that. But on the other end, if it's going down, then you may have triggered some covenant violations that need to be discussed and cured and maybe renegotiated. And I think sometimes that gets missed just because it's, well, that was a long time ago, we forgot about that. So make sure that you remain familiar with your obligations under that. And then I guess I throw on one more quick thing related to documents that are signed and then put in a drawer somewhere. And I know you guys have seen this, which is that an operating agreement that was set up between 4 individuals, let's say, and taxed by its default as a partnership. At some point in the history of the company, there was an S corp election. Well, that's a tax issue. That's not a legal issue. So why do we need to go back and look at our legal document? Well, because your legal document is very specific as to partnership tax and partnership tax treatment. And an operating agreement for a partnership looks different than an operating agreement for an S corp. And so you do need to go back and do the change. It's not catastrophic. The worst case scenario would be that if you were to go to, you had the obligation to be an S corp, and then you switched it to a partnership and you didn't modify the documents, I think. And so, but either way, there needs to be a modification to the governance document, which is your operating agreement, in order to coincide with your tax treatment. And so I've mentioned this before, maybe probably about a year ago, and then had some people on the line call me up afterwards and say, yeah, sorry, we're one of those people. We're one of those people. And I said, it was just to help you. There's no stigma or, I don't think any less of you just because you were smart enough to actually do what I suggested you did, right? I mean, it's just counterintuitive. So that's just another thing too, is just know your documents, both loan documents, et cetera. So, that pretty much covered, everything that I wanted to. I have other things that we could talk about, but I think it's probably sufficiently burning in people's ears at this point, and we probably should switch to more financial mistakes for next week, if that's.
We'll do that next week then. Yeah. And yeah, if you're mad at your landlord, pay him. Not that we haven't seen the repercussions of that, right, Adam?
Yeah, no kidding.
So also, hey, it is Labor Day weekend. So, if you're going to sport that seersucker suit and those white slacks, man, do it until Monday. And then you're in the fashion faux pas world if you're sporting white slacks or seersucker suits after Labor Day. So be safe out there and enjoy. We'll put this up on the BGW CPA YouTube channel later on this afternoon, and Shoemaker has the same sort of thing going on, so you can check them out if anybody came on late. Nice crew again. Thank you again, Jack, Adam, always good. And you guys have a great rest of the day.
Thank you. Have a great holiday, everyone.
All right, see y'all.
All right, thank
Bye-bye.
you.